Hello, everyone. Welcome to another episode of Immigration for All, presented by Noura Global and powered by Khulna Tech. I'm your host, 𝗧cie𝗽𝗶𝗰, for today's session. As you may already know that we have rebranded our popular Monday Life series under this new banner to better reflect our mission of providing the comprehensive immigration insights. As part of this revamp, we are excited to announce that this session will also be available as a podcast on Spotify and Apple Podcasts, so you can tune into our live sessions at your convenience. For today's session, our topic is latest updates on EB1A cases. In this session, we'll learn about most recent trends, processing times, and key factors influencing EB1A approvals, whether you are an aspiring applicant or someone supporting the client in this category. Today's insights from Mr. Mahajan will help you better understand the current landscape of EB1A immigration. Before we dive into the discussion, I would like to remind you all that if you have any questions or comments, please feel free to drop them in our comment box. Now, without any delay, let's welcome our guest speaker, Mr. Raju Mahajan, the Principal Attorney of Raju Law.
Thank you very much, 𝗧ši𝗽𝗶𝗰, for inviting me here, and thank you everyone who are joining, who are listening to us and watching us now, and will view us later. Let me go to our presentation, and then this is our presentation. So as I said, as 𝗧ši𝗽𝗶𝗰 said, today's topic is recent USCIS adjudication trends and policy observations for EB1A petitions. Before I go to my slides, let me remind you a little bit about what EB1A is, and a very brief, like a short introduction about EB1 if you already do not know about EB1. So EB1A is for extraordinary ability people from all over the world. They apply for a EB1A petition, and once they get approved, then they go for the second round, which is actual green card application for them and for their family members, and then they all can come to America. And people, those who are already in America, they can also apply for EB1A. Also, those who are not in America, those who live in a foreign country, they can also apply for EB1A. And EB1A application is so popular that it is commonly referred as Einstein visa, because most of the people who apply for EB1A, they're very, they're on the top position in their field. They're very prestigious person, and America is very proud to bring them here. That's why EB1A is so prestigious. And also in visa bulletin listing, there's a way less waiting period for EB1A compared to all other kind of categories. That's why EB1 is very demanding at this moment. And there's also a lot of approvals in EB1A cases we're seeing nowadays. Of course, there are some changes. That's why we're talking today. But in general, there's a way more approval of EB1A compared to other kind of visa categories. Also, many of you already know that there are 10 criteria for EB1A application. If you meet 3, then you can apply for EB1A. However, from our firm, we say that if you meet 5 criteria, 5 out of 10, then it is safe for you to apply for EB1A application, because sometimes what we let's say we claim that you meet this criteria, then USCIS will say that no, you do not meet this criteria. So that will kind of like put you in a position that you cannot get approved unless you meet 3 of the 10 criteria. That's why it is important to meet to meet 5 criteria before you apply. Let's go to the second slide. Where is my okay. So this is the general trends in RFE adjudication. Many people, you already know that when we apply for EB1A, we sometimes we get RFE. So what are the general trends of RFEs in this day and age? USCIS has adopted a more stringent and narrowly defined approach in evaluating evidence for each criteria. So this is a significant change. Even 1 year ago, USCIS was way more liberal, way more in favor of applicants to approve EB1A cases. That's why there was a lot of approval. Nowadays, there's a lot of approval too. However, EB1 is adopted a kind of more stringent and narrowly defined approach. So if the evidence is not strong enough, they will send you RFE, and they will ask a lot of questions about this particular evidence. That's why I advise my clients to try their best to provide as much evidence as possible, because we will try our best to make sure that your case is approved. That's why try your best to submit as much evidence as possible so that your case would be very strong. RFEs issued are highly specific, targeting evidentiary deficiencies and requiring precise documentation in response. Sometimes some clients, we see that they have tendency to provide some documents that's not precise enough, that's not specific enough, and it's not, sometimes it's very old, sometimes it is not on the point. So I advise my clients, try to provide very specific, very precise, as latest as possible, and as to the point as possible evidence, so that you do not get any RFE. Next slide. All right, so this is continuation of the previous slide. General trends in RFE adjudication. Broad or general assertions are no longer sufficient. Every claim must be established with specific, verifiable, and directly relevant documentation. Same thing I just mentioned. So if you submit something which is kind of very broad or very general in nature, nowadays USCIS is not satisfied with that. They want very specific, very to the point, very verifiable. That's very important. A lot of time. So let me give you an example. So let's say one newspaper, there's an article published in a newspaper, and USCIS said, what is the publication number? What is the circulation number of this particular newspaper? And then if we get a letter from the newspaper publisher, if they say, hey, we have like 100,000 publishing in a day, or 100,000 publication in a week, if we get the letter from the specific newspaper, it's not enough, because this is kind of like a self-describing number, right? We need something that is verifiable. That creates some extra layer of complexity for us, but we are happy to take any complexity, any extra work to make sure that your case get approved. Next slide, please. All right, so national or international awards. This is what, even though there are 10 criteria, and we see that if you meet 3, that's good, but national or international awards are really, really important for EB1 cases, because we claim that you are an extraordinary ability person. So if you are an extraordinary ability person and if you did not receive any national or international award, it's kind of hard for us to establish that. We saw some cases without awards getting approved. However, that's very rare. That cannot be example. In general, everybody who gets approved under EB1A, they have either national or international awards. So there was a policy change in October 2024. And what is the change? Previously, only nationally or internationally recognized solo awards were deemed sufficient. Under the revised guidance, team awards will now be considered valid, provided that each team member received individual recognition, for example, certificate, trophy, or medal. So previously, before October 2024, USCIS was not very excited to accept any award that was awarded as a team. For example, you were a member of a World Cup winning soccer player, right? Or you are a World Cup winning cricket player. So in a team, like in a soccer team or a cricket team, the trophy is for the team, not for any individual person. So before October 2024, USA is like, it's not for you, it was for the team. So we are not going to accept it as a national or international award. However, good thing is USA is like, okay, that's fine. You are a member of the team and the team got the award. So we will accept it as your award. However, you must receive something individually too. That's why you'll see that in Soccer World Cup or like in a Cricket World Cup, when they hand over the big trophy to the team, at the time of the big trophy, they also like put a medal in your shoulder, right? So that the point of that is to make sure that you will qualify for EB1A. So bottom line, if you win a award as a team, that's okay, as long as you individually receive a certificate, a small trophy, or a medal, so that we can claim that you are part of the team, right? So that's the key point. Next slide, please. All right. So, however, solo awards continue to carry greater, evidentiary weight. So this is another thing. In legal world, nothing is like concrete. Nothing is like 1 or 0. It's not binary. Legal world is very like one evidence will carry more weight than other one. One is stronger than the other one, kind of thing. So there's always like kind of like a judgment from every single angle. That's why law is very different. Sometimes when I talk to my STEM clients, it's very difficult for me to make them understand how law works, because they have like a science degree. Their entire career, their life is very binary kind of thinking, which is good for them. But for legal world, it's not 0 or 1. There's like a lot of gray areas. So even though USCIS is accepting team awards, however, solo awards continue to carry greater evidentiary weight. So if you receive a solo award, so let me give you an example of like a cricket. So let's say you were a member of the World Cup winning team. At the same time, you were the man of the match of that final game. So this award of man of the match will carry more evidentiary weight than you as a team member who won the World Cup. So this is the example. But if you get both, that's great. That's of course great. Field-specific alignments requirements. So the award must be directly aligned with the petitioner's field of endeavor. Awards received for achievements in related or allied fields are unlikely to satisfy this criteria unless the link to the extraordinary ability field is clearly established. All it means is the more specific the award is for your proposed endeavor, for your proposed extraordinary ability achievements, the better for you. So for example, let me give you an example. So let's say you are claiming that you are a coach. So you are applying for EB1A as a cricket coach, not as a cricket player. So if you apply as a cricket coach and if your award is as a cricket player, then it is not directly related, right? Because the award you received as a cricket player has nothing to do with being a coach. There's a lot of very good players who are not as good as coach. On the other hand, there are some great coaches who are not a great player, right? So the award the information about the award we are going to submit, if it is very related to the title you're claiming in your EB1A application, then it is better than if it is kind of like, kind of related or allied field. So kind of like a not so much directed. So that's not as good as if it's a very direct award for your profession or your designation kind of things. Next slide, please. All right, membership in associations. This is another very important criteria out of the 10. So there are some documentary requirements. Submission of fundamental documents of the association, for example, charter, memorandum of association, including the date and place of establishment is very important, because even though a lot of time we see that some of you are member of a great organization, however, they don't have any document. They don't have any charter, they don't have any memorandum of association, they don't have any website, they don't have any documents. It's very difficult for us to establish it to USCIS that this is a great organization and you are a proud member of that organization. So not only we have to establish that you are a member of that organization, we also have to establish that this organization is a prestigious organization and they have evidence for that. So please pay attention to this when you apply for EB1A. The membership must be based on outstanding achievements. Please remember this word, outstanding achievements in the same field of endeavor as explicitly outlined in the association's bylaws, memorandum, or equivalent governing documents. So as I said, the organization must be a prestigious organization and your proposed endeavor and their bylaws should match with each other. So let me give you an example. So let's say these, again, let's say you are applying as a cricket coach and you are a member of an organization where only top 20 international batsmen are member of that organization, right? Or any batsman who scored 10 centuries in international match, they are member of the club. So this is a very prestigious club, no doubt about that. It has established bylaws, memorandum, or everything is good. However, now we are going to apply as a coach. So this membership, even though it's very prestigious, the organization is very prestigious, it is not related to your field of endeavor. So the organization must be in the field where you are claiming your extraordinary ability, right? Let me give you another example. Let's say you are a very famous director, like a movie director. You're applying as a movie director. And your membership, it's a very prestigious membership in an organization where all the members are actors and actresses. The organization is not for directors, right? So you are applying as a director, but your membership with the organization is for actors and actresses. So even though it's very prestigious, but if it is not directly connected, it is very difficult for us to make this accepted by USCIS. So please pay attention to this kind of very specific kind of things. And nowadays USCIS is very serious about these matters. Next slide, please. All right. Applicants must provide proof that they meet all stated requirements along with corroborating evidence of recognized achievements. For example, media features, documented professional contributions, etc. Meaning, so let's say there are like 10 criteria, not 10, like let's say 7, because you'll be like confused with which 10. Let's say there are 7 criteria to be member of that organization, right? And if you meet like only 2 of those, and if they accepted you as a member, even though you're a member of the organization, it's not strong enough. Out of 7, if you meet all 7 criteria, or at least like 5 or 6, and then if you become member of the organization, that's stronger. That's why I said initially, it's not in a 0 or 1. Even though you're a member of the organization, but if you meet only 2 criteria and then you become the member, then it's not your strong evidence to submit to USCIS, and probably USCIS will not accept it. And trust me, they review everything. They review everything, all document very carefully before they approve any application. That's why it is very prestigious. Next slide, please. All right, published materials about the petitioner. Media ranking and circulation data. Evidence regarding the credibility of the media outlet, for example, circulation statistics, national rankings, must be independently verifiable. I gave an example about this earlier. So it must be independently verifiable. Data sourced from third-party or government-verified reports holds the highest evidentiary value. Self-claimed or unaudited statistics are not accepted. So this self-claimed is very common. A lot of time we get a lot of letters and other documents from different media outlets. They claim the best, the prestigious, the leading, the number 1, but everything comes from them. Self-claimed information, no matter how authentic it is, will carry less value compared to a government verified or a honest and reputed third-party verified documents. So anything verifiable is very important. Mandatory inclusion in submitted materials. Each article or feature must include the title, date of publication, and the author's name. This is another very significant area. A lot of time. So let's say a newspaper in India, right? I'm just giving an example. Let's say a newspaper in India, very famous newspaper, they published an article about you. However, in the place of name of the author, name of the journalist, they said our correspondent, right? They said our correspondent, or our diplomatic correspondent, or our entertainment correspondent, or our sports correspondent. Who is that correspondent? USCIS wants to know. And so the thing is, so let's say the publication has been published 5 years ago. There's no way to change it now, right? Because it's all been published. How do you change it? In that case, we try to take a letter from the newspaper and say that they will testify, like this news article was published in let's say January 21st, 2022, and the author of this article was journalist Mr. X or Miss Y. And this is our editorial policy not to mention the journalist's name because of this. That's why we did not mention it there. That's why it's not there. So try your best to submit articles that has journalist's name or the writer's name. But in case if the name of the journalist is not there, try to get a letter from the publisher to mention about the name and the editorial policy, why they did not mention it there, right? So that it will be stronger evidence for you. All right, we already went to the next slide. So critical or leading role in distinguished organizations. LORs, LORs stands for letter of recommendations, or testimonials now carry greater evidentiary weight than before. Previously, LORs was good, but it was not mandatory. However, now it's still not mandatory, but it carries a way more greater evidentiary weight than before. but only when issued by top-tier management or leaders of the organization. So let's say you are, you get let's say you are a famous soccer player from Nigeria. I'm just giving an example. A very famous soccer player from Nigeria, and Nigeria's football association's president is giving you a letter of recommendation. That will carry way more evidentiary weight compared to another player, another, you're like a colleagues, co-worker, your teammate kind of things, because the bigger office he or she holds, the better credibility that person carries, and it's good for you. So try your best to get recommendation letters or testimonials from the most famous person possible within your industry, right? Try your best. So that will definitely help you a lot. The recommender must have direct involvement or collaboration with the petitioner. Letter of recommendations from clients, colleagues, and experts in the field can only be accepted if they work directly with the petitioner and can attest to the petitioner's leading or critical role in such a project. As I said, if you get a LORs from your clients, your colleagues, and your co-workers, that's okay. But in that case, the petitioner must attest to the petitioner's leading or critical role in such a project. However, the bigger the position they hold, the better for your application. In our firm, we have a lot of clients from India, we have clients from Nigeria, we have clients from France, a lot of European actors and actresses. They apply for US green card and they get US green card, they stay here and they go back to Europe to act in their movies and make money, because America has a less taxes compared to Europe. So a lot of foreign actors and actresses, they come to America to kind of avoid their own tax system. That's totally okay. But I'm just giving examples. So when you apply for EB-1A, try your best to get letters of recommendations from top tier person and also your colleagues. But the more letter of recommendation you can get, the better for your case. Next slide, please. All right. All testimonials letters must be accompanied by supporting documents such as project report, published materials about the success, etc. Standalone letters are given diminished weight. So meaning, what does it mean? Meaning is, let's say you get a recommendation. So let's say you are a very famous French actress and you got a recommendation letter from president of, let's say, Cannes Film Festival. President of the Cannes Film Festival is writing a recommendation letter for you. If he or she is just writing a recommendation letter for you, it's okay, but it will carry almost zero value, right? Because just a letter you can get from anywhere. If you have personal connection, everybody will kind of give you a recommendation letter. So the best case scenario is if you can get a recommendation letter from president of the Cannes Film Festival, at the same time, some report, like a project report or published material about your success and other thing that has to do with the Cannes Film Festival. These two things, recommendation letter and the report together, will carry way more weight than just the letter. I hope you understand things. If you do not understand, please send us an email. We'll try our best to help you. Next slide, please. All right. So those are kind of like a specific areas. Now I'm kind of giving you kind of like a general kind of idea about different evidences and other things, just kind of like a in general discussion. So in cases where the 10 regulatory criteria do not directly apply to the nature of the applicant's occupation, the petitioner may submit comparable evidence to establish eligibility under the EB-1A category. All it means is, in the very beginning of this presentation, I said there are 10 criteria that must be related to your occupation. But in some occupation, you cannot meet 10 criteria. You even cannot meet like 5 criteria because they don't have any award. There are some sectors in the world, like me being a lawyer, there is no award. There is no competitive award for lawyers. So if you apply as a very famous, lawyer from India, and if there's no award, how do you present? How do you give information about it? You cannot. So if you are in an occupation where there is no, comparable 10 regulatory criteria, that's okay. You can submit similar kind of information. So let's say you are a member of the Supreme Court of the Supreme Court of India Bar Association. And let's say you won a very prestigious case, and there was like a huge news report in Times of India and all other famous newspapers and television channels. So you as an attorney, you as a lawyer, if you can establish that even though you do not meet all these 10 criteria, however, you are extraordinary ability person in your industry, that's also okay. USCIS will also accept it. So this is kind of like for those who cannot easily meet this 10 criteria. However, it is important to note that merely satisfying 3 of the 10 criteria is no longer considered sufficient unless the supporting evidence is exceptionally strong, comprehensive, and clearly indicative of extraordinary ability. So initially, in the very beginning of this presentation, I said, according to USCIS, if you meet 3 of the 10 criteria, you're good to apply. However, just merely meeting 3 of the 10 criteria will not ensure your acceptance, your approval of EB1A, unless all the supporting evidence, all the information, all the recommendation letters, all the testimonials, all the things you are submitting are very strong, very exceptional, and very comprehensive. Otherwise, I strongly advise you to try to meet 5 criteria before you apply for EB1A. Next slide, please. All right, another thing I say every week. So, this video is live broadcasted in YouTube, Facebook, and LinkedIn. However, we also have podcast in Apple Podcast, Spotify, and other major podcast media. So those who are listening to us, not seeing it, not watching our presentation, I'm showing a PowerPoint presentation. However, whatever in the PowerPoint, I'm explaining everything very clearly. So even though you are not watching my video, that's totally okay. You are not missing anything. I'm explaining everything verbally. So if you just listen to me, you'll get all the information. All right. USCIS has adopted a more rigorous approach, placing increased emphasis on the quality, relevance, and probative value of the evidence submitted. As a result, it is now regarded as best practice to submit documentation addressing more than 3 criteria, ensuring that the totality of the evidence unequivocally demonstrates sustained national or international acclaim and recognition in the field of expertise. So all it means is, even though when you read USCIS website and other place, you have idea, oh, if I meet 3 of the 10 criteria, I'm good to apply, I'm going to get it approved, I'm going to America with a green card. It's not the case anymore. Now USCIS kind of focus on the quality rather than quantity. Even though if you just meet 3, if all of the documents you're submitting, if those are like really, really good quality, that is going to help you get approved. On the other hand, if it is not good quality, it will not ensure your approval. So try your best. I say this to all my clients, no matter for EB1, NIW, or anything. Try your best to spend some time, build your profile before even you think of applying. Because if you apply without proper preparation, yes, you can definitely apply. That will be waste of your time, money, and energy. I do not want you to waste your time, money, or energy. Take your time, build your profile, and then you apply. That will help you get it approved, come to America with a green card with your family, and you can even enhance your career further in America. So that was my short presentation. Next slide, please. I think, yeah, as I said, this is my short presentation. If you have any question, please ask us now. We are going to answer those. Going back to 𝗧ശിഖ്ശ.
Thank you so much, Mr. Mahajan. That was a really insightful presentation. We'd now like to take some questions from the comment box. The very first question is, do you have any office in Virginia?
We do not have any office in Virginia. However, our office in Washington, D.C. area is in Bethesda. It's a very close neighborhood from Washington, D.C. and also very close from Virginia. If you cross the river, there's a river called Potomac River. If you just cross it, Bethesda is the first place. So even though we do not have office in Virginia, but it is very close from Virginia.
Okay, so the second question is, good day, sir. As asylum seeker, can you submit a work permit application 1 day to 150 days reach?
Excuse me. Number one, today's this point of discussion is not about asylum. However, since you applied, so your question is, can you submit a work permit application 1 day to 150 days read? So yes, so you can only submit it after your 150 days time limit. You can get it ready, your application and everything will be ready, we'll prepare it, but we'll only submit it when you can submit. Otherwise, USCIS will not accept your application before the deadline.
Okay, I think that this is the third and the very last question. Assalamu alaikum, sir. I am an Italian citizen. How can I settle in the USA?
This person, he's in the same question every day. I already answered you, but why you ask same question every day? Well, thank you very much for watching, of course. But yeah, there are multiple ways, and I think I already answered this question.
So with that, our question and answer session comes to an end. Thank you, Mr. Mahajan, for answering all of the questions and for your valuable time.
Thank you very much, and thank you, everyone. Have a wonderful day.
Thank you, sir. And thank you, everyone, for participating. Dear audience, thank you so much for attending. Next week, we have another live session scheduled at the same time, 11 a.m. EST, 9 p.m. BD time, and Nepal Standard Time, we have 8:45 p.m. So that's all from me for today. I'm signing off now, but don't go anywhere because our weekly immigration news is up next, bringing you the latest updates, policy changes, and announcement from the world of immigration. Till then, have a great week. Thank you.
Welcome to the latest episode of Weekly Immigration News by Roger Law. This week, we brought to you 4 latest updates in the immigration arena. Let's start with the headlines. 55,000 selected in 2026 U.S. diversity visa lottery for green cards. Trump seeks Supreme Court approval to end legal status for 400,000 migrants. ICE expands student deportation powers. Trump offers $1,000 and travel for immigrants to self-deport. Let's get into details. The U.S. State Department announced the results of the 2026 Diversity Visa DV Lottery, or Green Card Lottery. Of the millions who submitted their names in the lottery, only 55,000 individuals were selected to apply for U.S. permanent residency. The DV Lottery offers a path to a green card for people from countries with historically low immigration rates to the U.S. Next up, the Trump administration has asked the U.S. Supreme Court to approve its plan to revoke temporary legal status for over 400,000 Venezuelan, Cuban, Haitian, and Nicaraguan migrants granted under a Biden-era program. A federal judge blocked the termination in April. Trump's team argues the program undermines immigration enforcement, while critics warn mass termination would harm families, communities, and the economy. The court has given plaintiffs until May 15th to respond. Moving on, a week after reinstating legal status for foreign students, immigration officials introduced a new policy granting ICE broad authority to revoke that status. The policy permits revocation based on vague claims of non-compliance or visa cancellation without evidence or judicial oversight. Critics argue it could lead to a fresh wave of deportations and undermine legal protections. Immigration lawyers say the policy reflects ICE's efforts to expand its powers and bypass recent court rulings that protect international students. Finally, the Trump administration is offering $1,000 and paid travel for immigrants in the U.S. illegally who opt for self-deportation. By using the CBP Home app, migrants can inform authorities of their departure and avoid being prioritized for detention. Homeland Security describes it as a cost-effective alternative to arrest and deportation. Trump suggests that those who leave voluntarily may eventually have a chance to return legally. Critics argue the program is coercive and dehumanizing. One migrant has already taken up the offer.